Bruno, the question is, can two shareholders of a residential property put the property up for sale if there's a dispute? And he goes on further and says, and all except one shareholder is deceased. He says the deceased shareholder's portion has not yet been wound up. So he also goes further and says that there are heirs involved or heirs involved in this particular situation, children. Bruno, what advice can we give the viewer here?
Sorry, so if I understand correctly, you said the property had two shareholders. So I'm assuming the two are the live ones. You said all but one has passed away. So is there only one left?
That's what it sounds like.
It feels like a word song. You have two apples and then the lawyer mathematics.
Okay, so I'll try maybe answer this more generically, so that it covers a couple of different scenarios. So first problem, the use of the word shareholder, just for the sake of avoiding confusion. When we speak shareholder, because of our company legislation in South Africa, or company law legislation rather, we typically associate shareholder with companies and the actual holder of a share in a company, right? So we don't use shareholder when it comes to property, but I do understand the nature of the question, but I'm assuming that the property is not held by a company that's then held by shareholders. It sounds like the property is held directly by these individuals, so they're co-owners. And from the sounds of it, there's two co-owners. One has passed away, if I'm not mistaken. But even if there's several and two are alive and two have passed away, or three and one, it doesn't really matter. The bottom line is there's a kind of a mix here. So there's joint ownership over a property. Now, in South Africa, it's not defined. So the ownership over the property is not defined to a specific area of the property, right? Not like when you sectionalize, for example, that you can buy a section in a larger piece of property and you can own that specific section. When you just buy a property and you co-own the property, it's an undivided share in the property, which means that you can't technically draw a line down the middle and say that I'm going to sell my half and you do what you will with your half. That's not how it works. It's an undivided share. So to deal with the property, unfortunately, there has to be a level of consensus, because now there's an assumption that there's some kind of partnership in place or some kind of commercial arrangement in place. The nature and form of that agreement, we don't know. Obviously, we don't have enough information, but there's something in place. Now, the key to this question or this answer is, what is that something? We can't really give an answer unless we know what the plan of action was. Even if the partner has passed away, it doesn't matter, because if you had a good plan of action with a good contract that had execution steps that dealt with things in a very specific way, then you're still good to go. You just need to look at where the estate is, how far it is from being administered, and what that plan of action was. So there's a lot of JV agreements, as an example, partnership agreements that deal with what's going to happen with the property once a person passes away. Either the other partner gets first right to buy that property from the estate, or the undivided half share is just passed down to the person's beneficiaries, or maybe the property is just sold. There's a level of liquidation that takes place, right? I'm assuming from this question that isn't the case. There isn't an agreement in place. So the estate wants to sell the property, and you as a property owner, the person that hasn't passed away, that partner, wants to retain the property. And so no one can force someone to sell the property unless there was a contract that allowed for it. So if you want to keep your undivided half share, you're welcome to keep your undivided half share. What you do need to be warned about is, unless there's some form of restriction I have seen people sell undivided half shares in properties, and that does make things very, very complicated, because unless there's a restriction saying that he's not allowed to sell to anyone but you, or the estate isn't allowed to sell to anyone but you, they're going to sell it off. And since no one really wants to buy an undivided half share, you can be sure that the value that's going to be paid for it is going to be very low, which is probably going to impact the value of your undivided half share. And the person buying it is probably going to be a bargain hunter, because no, and I mean, this is just from experience, the people that I see that take chances in buying undivided half shares and shares in companies where they don't know what debt this company has, those are bargain hunters. They know what they're doing. They know how to strip properties. They know how to strip companies. So you might land up with someone that you don't really want to be dealing with. But that being said, I doubt their estate would sell an undivided half share unless their estate is insolvent. Reason being that they want to raise as much money as possible. And everyone knows that if you try and sell an undivided half share, you're not going to raise that much money. So they're better off negotiating with you, trying to find some kind of middle ground, or getting income from the property or something along those lines. So there's the legal answer, which is they can do it. The practical answer is don't let them do it. Have a conversation with them that kind of eliminates that uncertainty and that risk.